Podcast.
Good morning and welcome to this week's edition of It's Chaile Time. Just last week when I spoke about when negotiations turn personal, we spoke about employers and employees, their unrealistic expectations when they approach conciliation negotiations for settlement. Parties, they're not open-minded, they only look after their own interest. Yeah, this week again, actually yesterday as a matter of fact, CCMA Pretoria, this case been going on arbitration for a while now, and at the end of the day we had conciliation, and you know what, now you walk in there and Commissioner asked any possibility of a settlement, and out of the blocks immediately the employee, she wants 12 months compensation. I mean, that's like maximum compensation for an unfair dismissal dispute, or this was a dismissal dispute, and I'm just like, women. Don't you understand in life? No, it's not just about me. People are only looking at my interest, what I want. Now she immediately wants 12-month compensation, but she doesn't understand and appreciate there's another party with needs and interest sitting that side. You don't negotiate like that, okay? Because the reality of the matter is a person didn't work there long. We as an employer, we actually have a very strong case. When I say we as an employer, I don't mean it's my case. It's one of my clients' cases. It is like going through a divorce, I can only imagine your spouse wants everything, the house, the cat, the dog, the cars, the job, the money in the bank account, everything. And you must not go sleep there on the corner of the street. I don't care about you. We immediately close that door. You know what? We're not going to talk or entertain settlements. We're just going to go into arbitration. You can go and apply for arbitration. And I'm like, she's actually represented by a lawyer. So I'm thinking by myself, lawyer, didn't you do your work? Don't you prepare her? First of all, she's got a weak case, But secondly, most employers are always open for some form of settlement. And the reason being is when I prep an employer, and I say to them, look, let's get the emotion out of this. This is not about who's right and wrong. This is really about, the legal process itself. Some form of settlement takes it away, and you get that. Okay, if I have to thumbs up, probably 90% of the time, if an employee loses a case at the CCMA, they won't go for review at the labor court. But there's that 10% thumbs up, And I've seen that where employers should have settled on a small amount. Now it's 200,000 rand, papa? Now it's labor court, and who knows? Maybe even the labor appeal court thereafter, So a settlement always makes sense from that perspective. Then, also this week, interesting. I've just once again seen, how important it is that parties be represented at the CCMA, especially employees, They don't always understand the legal context of what's happening in front of their eyes. I represented an employer, also conciliation, and look, this employee was dismissed for corruption and fraud, and she does not have a good case, nothing at all. The company was quite fair in their process, but that's my opinion. Also, conciliation, I want 12 months. I'm like, darling, it takes two to tango. There's two to this table, not just you. Your interests and your needs, me. Yes, I gave her gas. And something I realized is that in the era we lived in, sometimes people don't understand what they're doing is stealing. This person, poor soul, took the company's credit card, copied the details onto a laptop, and started making unauthorized transactions. And you know what? It took me about half an hour to make her understand that she was committing fraud. It is like, and for her, it was just like, but this is a digital age we live in. Because sometimes, she needs to make payments, and then the company will give her the card, you see. But that is not what happened here. She didn't have any authority to simply start copying bank details. And what if her laptop gets stolen, But you don't understand it. You just don't see it. It's just like, absent, Sometimes in a hearing, I will tell people, you've now been found guilty on sexually harassing a staff member. What you should do is go back to your home, look yourself in the mirror and say, you have a problem. You actually need to identify, in the era we're living in, somebody needs to identify that if they take something from somebody that doesn't belong to them, it's called theft. You are now stealing, because if you confront a person, you are stealing. No man, I was just incidentally taking something that wasn't mine and ... It's, people don't really understand it. But anyway, to come back to why employees also need to be represented. So now, on the one hand, you seemingly have an employer that seems to be extremely honest. The employee eventually accepted the 1-month settlement, provided we give her a neutral reference letter that clears her record. So obviously, somewhere there, we're going to have to put in the reason for termination of service, and we can't say she was dismissed. So the commissioner, out of her own, started writing in the settlement agreement, end of contract. So I look at it and I'm like, no. Phone the employer says, not a chance, because it's actually a lie, It implies that she was on a fixed-term contract, and she wasn't on a fixed-term contract, And also the employer, because it's a small industry, they didn't want to create the impression that they left on good terms, because, if somebody else in the industry phone or employs the person, and then they see that the person was employed by them, there can be brand repercussions for the company. So I'm sitting literally in the middle of two parties here, okay? So at the end of the company agreed to use the words mutual separation, which is just technically is, because this is now what's happening at the CCMA in terms of the settlement. But okay, so now the commissioner also agreed, mutual separation doesn't directly speak to a dismissal, and the employee, okay, no, that makes sense. But this is the thing. She doesn't understand the full legal context around the mutual separation agreement, which mostly implies that something went wrong in the relationship, probably either because of your performance or the lack thereof, or misconduct, and therefore you're mutually parted ways, because a mutual separation agreement, we all know, is always in full and final settlement, and there's some extra money there, and whatever the case may be. So a potential employer is going to read mutual separation as a reason for termination, and they're going to be like, I wonder what happened here, So it's got practically it's got the same impact as though it said there you were dismissed for misconduct. But no, the employee didn't know it, signed it off. Sometimes I do feel sorry for this, but I suppose that's a process. That is a process. Okay, just some interesting things in the news. Our police minister, Senzo Mashunu, I just read now in the news this week that he's been put on special leave as a police minister, and also he's been relieved of his duties at the ANC. And this is because allegedly he's been having relations with the underworld, whatever that means. And then also for disbanding the political killing task team. So I think there's a lot to watch in this space. But did you know, well, this is an interesting one, this is a good one, did you know that BEE in South Africa was not invented by the ANC? Yeah, it's in the news this week. It was actually invented by a white Afrikaner called Attie du Plessis. He was in the leadership in the 80s of Sanlam, and the then ANC leaders who were in exile, they had meetings with some business leaders in South Africa, and Attie du Plessis invented the idea of BEE, and actually the very first BEE transaction took place when Suncorp was the investment arm of Sanlam. Sold some of their shares in Metropolitan Life to African Corporate Africa, which was owned by black people. So that's actually the first BEE transaction in South Africa. So there you have it. It's interesting. The white Afrikaner is the inventor of BEE. Okay, so domestic workers, household domestic workers, year on year, the employment been declining, 17,000 less jobs this year, which is a decline of 1.5%, and also 150,000 jobs since COVID. Apparently the two main reasons, immigration, so apparently South Africans are immigrating, and then also the poor state of the economy, a lot of households under financial stress. Good news, in spite of Donald Trump's 30% tariffs. Our citrus exports this year, 2025, is up by 22%. But they are saying we are waiting for the 2026 season, because apparently that is when the effect of the Trump tariffs will hit. But so far this year, the citrus farmers keeping it up, making South Africa proud. So what are we talking about today? Now, today is a very interesting topic of conversation. I'm dealing with, the title is the notice trap, or the notice pay trap. An employee, we have a bit of a problem. There's some areas in labor laws, in labor relations in South Africa, where there's a bit of an issue, okay? And one of those issues are an employee resigning with immediate effect, not working notice, and subsequently the employer withholding your last salary to make up for the notice you did not work. It sounds so right, it sounds so fair, but is it? Now, before you start throwing me with stones or beer bottles or milk cans, I know there are two schools of thought here. There are those that says, but we've got a clause in the contract that states that if you fail to work your notice, the company can deduct from your last pay the equal amount from your remuneration to the notice period you did not work. And you know what? We got away with it at the CCMA. Well, I also know about cases where people did not get away with it at the CCMA in terms of the validity or legality of that contract per se, or that provision in the contract. But let's dive a little bit deeper into some of the legislative provisions that deals with this matter or that doesn't deal with this matter. And then let's just look at also at a fairly recent case law, labor court case that sort of speaks its mind on this matter, because I can appreciate that on the face of it, it does make sense to withhold a person's salary. But anyway, so the starting off point really is, I think we need to delve a bit deeper into the basic conditions of Employment Act. And the starting off point for me is Section 5. This act not affected by agreements. So this act or anything done under it takes precedence over any agreement, whether entered into before or after the commencement of this act. So that provision does not nullify agreements. It doesn't say agreements it's not necessarily valid. It's just saying the provisions of this act itself take precedence, okay? So in principle, just the fact that you have a provision or a clause in the contract does not mean that seals it, okay, or that seals the deal. Some employers, for instance, a lot of employers actually think that just because it's in the contract and both parties sign, you shop. Now, in common law, you are shop. But, we've moved on from common law per se. I suppose from some perspective, common law is like the foundation. But, if you want to know how laws have built on this foundation, you must actually watch my one webinar, Legal Compliance. It will explain to you common law, the foundation, and where collective bargaining comes in, and collective agreements and statutory agreements and legislation and statute, the constitution, where everything comes into the mix. But common law is not the predominant factor that we take into consideration in the employment context, because we have laws, and this one is the BCEA. So I think Section 5 is a good starting off point. So that tells us that just because there's a clause in the contract that says, hey, I can deduct notice pay, doesn't mean it's enforceable. Okay. Yeah. Okay. So now let's move on to, I think that this Section 37, Section 38 specifically deals with notice of termination of employment, and Section 38 payment instead of notice. So Section 37 deals with notice periods. It basically states that either party must give notice based on the following calculation. If an employee works up to 6 months, you must give 1 week notice. If an employee works between 6 months and 12 months, you must give 2 weeks notice. And if an employee worked for more than 4 weeks or 12 months, you must give them 4 weeks notice. And basically, you obviously pay a person during the notice period for them as part of their normal remuneration. But Section 38 now provides that if an employer, for instance, don't need or require an employee to work their notice, and they can let them take off, you must still pay the employee for notice. But now the predicament employers find themselves in, and I think this is it's a South African thing. I think it's a cultural thing. And yeah, I'm talking about all South Africans. It's like an employment cultural thing. I don't know what it is with us, You will agree in advance that the law say you must give notice, but when it comes to that other opportunity, you just resign, There's no, it's a summary resignation. You just skedaddle, We don't respect employers anymore. Personally, I will find it difficult to do that, and I have in times past also left my job, but you know what? You work your notice, because at the end of the day, I can't afford in life to burn down my bridges. And I also know, the future employer is going to phone the guys at the previous employer, going to phone them, ask them, what happened here, you see. So, and you don't want that employer to say, that scallywagon, Okay, anyway, so Section 34 deals with deductions and other acts concerning remuneration. Now, these are peremptory provisions. That means basically these are the reasons for what you can make deductions, okay? And nowhere here does it say an employer can per se directly deduct for failure to work notice. Section 34 doesn't deal with that. Ultimately, it doesn't mean you can't, and I'll explain where that comes in, okay? But in principle, you can't really, okay? So, subsection 1, employer may not make any deduction from an employee's remuneration unless, so right there, from the start, get go, okay? You can't make deductions unless on the following provisions. Number 1, A, subject to subsection 2, the employee in writing agrees to the deduction in the respect of a debt specified in the agreement, okay? So, this is one of the grounds where you actually can make the deduction. So, let's assume the deduction is 20,000 Rand. Let's say the person's salary was 20,000 Rand as an example. And that person signs an agreement that says, the employer may deduct 20,000 Rand from my salary, okay? Because I'm not working notice. Then I suppose it will be sharp, okay? I'm just not so sure if I know about an employee what will agree to that. But, okay, there is some room there. And B, the deduction is required or permitted in terms of a law, a collective agreement, court order, or an arbitration award. So garnishing orders, for instance, this is where if the employer gets a garnishing order, poops, your money's going to disappear out of your pay. But also this one collective agreement, because you will find some collective agreement, and I'm aware of two, the Restaurant Bargaining Council here in Johannesburg and also MIPCO, where there's a provision in there, and that main agreement is in the collective agreement. It actually provides that an employer may deduct, okay, if an employee fails to work notice. So I think there it will be fine in that context, okay. But then it explains in subsection 2 the procedure to deduct, okay? So a deduction in terms of subsection 1A may be made to reimburse an employer for loss or damage. Now that word damage is sort of key here, okay? But only if the loss or damage occurred in the course of employment, okay, and was due to the fault of the employee. The employer, just on that A, it's debatable whether the notice period falls within employment because, the employee is no longer employed. He left, Anyway, that's debatable. B, the employer has followed a fair procedure and has given the employer a reasonable opportunity to show why the deduction should not be made. So you need to have some kind of audi alterum partem opportunity or engagement. I want to steer away from a disciplinary hearing or a hearing because it doesn't necessarily have to be so formal. We're not talking Schedule 811 here, okay, in terms of a fair procedure. So there must be like an audience. You give the employee an audience, an opportunity to make representations why not to deduct, okay. C, the total amount of the debt does not exceed the actual amount of the loss or damage, okay. And the reason why I'm focusing on damage because when we deal with a court case, they elaborate a little bit more on the philosophy of what is a damage. Okay, anyway. D, the total deductions from the employee's remuneration in terms of this subsection do not exceed 1/4 of the employee's remuneration in money. So there you have it. So strictly speaking, in terms of section 34, You can't make a deduction more of 25% of the person's salary anyway. So I don't think you necessarily going to find recourse as an employer in terms of Section 34 per se if you want to make a deduction of notice pay, because there you can see there's no provision here that say that you can do that, strictly speaking. Unless, of course, if you're in a jurisdiction where there's a bargaining council collective agreement that provides for that, and also if the employee sign off specifically for that specific deduction, okay? So let's go to the court case. What is this case? Let's see here quickly. South African Music Rights Organization Limited versus Mafatso. And this is 2009, the Labour Court had to decide whether the company had a claim for damages when the employee did not serve out his notice period, thus emanating in breach of contract. The court stated the following. The introduction of a contractual right to fair dealing in the employment relationship calls into question the assumption that the purpose of damages for breach of employment contract is simply to protect the aggrieved party's interest in a denied period of notice or the unexpired portion of a fixed-term contract. Breaches of mutual obligations of trust and confidence are unlikely to be remedied by an approach to the assessment of damages for breach of an employment contract such as that for which SAMRO contends. Essentially, the claim for damages on the part of the employer accordingly failed. So, what this case really tried to question is whether, when you have a provision like that in the contract of employment, it's very simple for an employer to say, okay, there is now damages. And that damages automatically equates to economic damages. So if an employee or a party breach a contract, it means money, you see. And so what the court is saying is that when there's a breach, let's say this kind of breach, it also speaks to the heart of the trust relationship between the employer and employee. So it is not automatic that a breach of such a clause equates to financial loss. It's not automatic, you see. So that's why they're saying that if an employee do not work notice, an employer cannot simply deduct money. Okay, for the employer it is very simple, it's money. But from a legal perspective, the damages is not necessarily automatic money, financial. It can be, but it's not necessarily so. Okay, maybe there's a deal that the employee, if the person is a salesperson, they're busy closing a deal with a client. So a resignation on immediate effect can have reputational damage. So it's not necessarily automatically financial. So you can't really have this provision in there that says, let's just deduct money. You see, what about enforcing the employee to work and concluding the deal as an example? That's why the courts are saying, look, you have the right to take civil action against this employee for breach of contract, breaking the law, and then you can go and motivate your damages at the court. Now we know most employers won't do that because often it's low-level employees and the cost involved just to follow suit, is not worth it. Okay, so I understand this is where the big issue is coming in. It's a bit of a, thank you legislation for giving us this recourse, but no thank you because it's not practical. We can't really implement, we can't really do anything about it. Really, it's not practical to do so. We will just go on the duck. But now for the employee, where is my cricket ball? I don't have my cricket ball here. Okay. There is something now for those who are learned, for those who are looking at this podcast, if you're a commissioner or a judge, you didn't hear anything. Okay. There's also what I call the dark arts of labor law. Okay, this is normally where I throw my cricket ball. So when I do IR training, I normally at this stage, I throw my cricket ball at the audience they catch, because sometimes litigation is like a ball. You throw the ball and you see what the other person is doing with it. Are they playing the game or just dropping the catch? But anyway, so I actually had this case with an employer this week. And the employee didn't work notice, and the employer asked me, look, can I deduct, this is how the conversation on WhatsApp started, can I deduct the person's failure to work notice from the person's last salary. So I said, no, you can't do that. I mean, there's no such thing as a free lunch. You go to pick and pay to take a bread, you pay for it. The person worked, you must pay for it. But I do know that the CCMA don't have jurisdiction, and this is where my message of dark arts is now coming into the employee. Don't think that if you don't give notice, there's nothing the employer can do about this. There are some devious tactics these buggers will do, or can do, which probably will mean you'll need to get yourself a very fancy lawyer and advocate to go fight a battle at the labor court. So the employer asked me, but I know the CCMA don't have jurisdiction. So I said, yeah, okay, the CCMA don't have jurisdiction to deal with deduction disputes. So if we deduct from this person pay, even if it's unfair, the CCMA don't have jurisdiction to deal with it. I said, yeah, that's true. But then the person goes to the labor court. Oh, but that is a risk we're willing to take because that's going to cost a lot of money and a lot of time. And you know what? Between you and I, most employees don't have the resources all the time to really go fight over 3,500 or 4,500 rand if we have to go on minimum wage here. So this is the thing. Section 77 of the Basic Conditions of Employment. Here somewhere. Here it is. The jurisdiction of the labor court, subsection 1, subject to the Constitution and the jurisdiction of the Labor Appeal Court, and except where this Act provides otherwise, the Labor Court has exclusive jurisdiction in respect of all matters in terms of this Act. That includes section 34. So if your employer makes unlawful deductions, you're going to go to the CCMA for conciliation to see if you guys can settle the dispute. But if not, thereafter you must go to the labor court. So don't think your employer can't get even. There's nothing like getting even. At the end of the day, an employment relationship, it's a relationship, people. And I see that every day. Dispute resolution is what we do. And in a way, it's beautiful because what you see is, even though sometimes it may be criminal, people are trying to hit each other, smack each other, and curse each other, and trying to screw each other. What you have at the heart of it is humanity. You have one person and another person that aggrieved with each other. There's something that went wrong in that relationship. And for me to try to resolve that is beautiful on its own. But you know what? You work with humans, Just as an employee tried to screw the employer is going to try to screw you back. So if you're an employee and you try to resign without giving notice, be mindful there's going to be a lengthy battle. Another example, quickly, one of my other clients, their payroll manager resigned. This was like 5 months ago or so. He filed a constructive dismissal dispute and filed a Section 73 dispute for his leave pay. The case manager at the CCMA phoned him and said, "Listen, Sunshine, the CCMA don't have jurisdiction to entertain your Section 73 dispute because you earn above the threshold. So that door is closed already." He failed in the constructive dismissal dispute because he wasn't constructively dismissed, and that left him in limbo. Then he sent emails and threatening WhatsApps. You owe me leave pay. The client knew they owe him leave pay, but you know what? They wanted him to suffer a bit, And, on an emotional level, I agree with the employer. This employer is a very kind man. And this employee and his wife got involved and cursed him and swear him. And you know what? Honestly, I don't always bad for employers. Sometimes I think employers are assholes, okay? But not in this case, okay? And I emotionally thought to myself, yeah, you bugger, you will wait until the last second. So literally 2 weeks ago, and this he should have done right from the beginning, he got a lawyer involved who said, "Listen, I'm giving you 14 days to pay or we see you at the labor court." So the employer phoned me, "What must I do?" So I said, "It's time to pay." And he paid. But actually what the employer wanted is, and I actually told the guy this on WhatsApp, humble yourself right in the beginning, just say sorry for your behavior and he would have immediately paid you. You see, so there's this tit for tat, dispute resolution, the interest of both parties. Next time you go into conciliation, look at your case objectively and ask yourself, am I going to get 12 months here? Because the reality of the matter is, 12 months. If I must pay 12 months, I wouldn't have dismissed you in a hearing. I would have chased you away as a dog, and I would have just wrote the check on the way to the CCMA. That's this week for It Is Chaile Time. Let's do some job review and get some people employment out there. At the end of the day, we are Effectus Harmony. We try to create harmonious relationships. It may not always sound like that. But yeah, so if you do need some help, we represent employers typically because we belong to an employers organization. So employers out there, you need some HR help, IR help, BE help, transformation, payroll, employment equity, skills development, health and safety, name it. I'll even make you coffee. See you next week. Bye-bye.
Good morning, everyone. Let's have a look at some of the vacancies posted nationwide on our Harmony Peoples Network this week. First up, Moses Koteny Research Institute is looking for an HR manager. In the Free State, there is an opportunity for an accountant. Ambit Connect is recruiting for a product manager, and Pinnacle HR is advertising for an intermediate software engineer in Johannesburg. For the full information of the mentioned positions, how to apply, as well as more available positions, find the vacancy link in the description. You will also find a link to a useful video on how to compose a winning CV and have a successful interview. Tune in again next week for more Harmony vacancies.